Hi, my name is Andy Hall, and I'm an anti-trafficking activist. I also just became an attorney and a member of the Arizona Bar, having graduated from U of A Law in May of this year and passed the bar exam. My bio's in your materials, so I'll spare you. But suffice it to say, I've been involved with anti-trafficking education and activism for about 6 years now, and I went to law school in order to gain practical skills in order to help survivors of human trafficking. I'm sorry I can't be with you today in person. I had to appear by video because I'm currently in another country for a language immersion program. I'll try to keep my comments pretty short so that you can hear more from Beth and Savannah. But today I want to present some proposals for anti-trafficking reform in Arizona. There should be a handout in your packets entitled An Agenda for Arizona Anti-Trafficking Reform that summarizes my proposals and provides some further reading and legal scholarship for each proposed reform. Feel free to refer to that throughout, although I may go in a little bit different order. I want to offer some common sense state-level fixes for statutory deficiencies that continue to plague trafficking survivors in Arizona, problems which I'm sure my survivor allies will be able to speak to more poignantly and personally. You may ask why I'm focusing on Arizona law rather than federal, given the nationwide and even global scope of the trafficking crisis. The short answer is because state law is currently way worse than its federal counterpart. Although not perfect, the Trafficking Victims Protection Act and its subsequent reauthorizations provide a reasonably good federal foundation to prosecute traffickers, protect victims, and prevent trafficking. In contrast, I'm afraid Arizona is pretty much a case study in inadequate state anti-trafficking law. That's why Polaris, the most prominent anti-trafficking NGO in the US, ranks Arizona's anti-trafficking laws as the third worst among all 50 states. Even as most states' anti-trafficking laws and victim protection regimes have dramatically improved in recent years, Arizona's laws have remained relatively flimsy, especially as it pertains to trafficking survivor protections. We've fallen behind other states, and politics have too often gotten in the way of common sense solutions. I'm also focusing on Arizona law today because the war on trafficking will be won or lost at the state level. The institutions most likely to come into contact with trafficking victims include the education system, the child welfare system, the criminal law system, and the healthcare system. These are primarily creatures of the state legislature. States, not just the federal government, need to pick up the torch. They need to investigate and prosecute trafficking, provide services to survivors, and scale up prevention efforts. Until states take the lead, most trafficking will slip through the cracks. You might also be wondering where my proposals came from. They came from two main sources. The first is something called the Uniform Act on Prevention of and Remedies for Human Trafficking. It's promulgated by the nonpartisan Uniform Law Commission, which wrote model state laws, most famously the Uniform Commercial Code, and many others as well. The Uniform Act on Trafficking passed several committees of the Uniform Law Commission and the American Bar Association unanimously, showing its broad bipartisan appeal. And the Uniform Act on Trafficking is intended to be a model, comprehensive state anti-trafficking statute for state legislatures to borrow from or adopt in full. If you Google it, you can read the full text online, and it's an excellent law. The second key source for my proposals is the legal scholarship surrounding human trafficking and the law, especially that which looks at what other states have tried and what's working. Some of that material is cited in your handout if you're interested in further reading. So let's get down to the specifics. I want to offer 6 specific legislative reforms for Arizona to improve our anti-trafficking regime. First, and maybe most importantly, is something called safe harbor. In the context of trafficking, a safe harbor law is a law that enshrines the following bedrock proposition: there is no such thing as a child prostitute. There is only a prostituted child. A minor in prostitution is a crime victim, not a criminal. It makes all kinds of sense. Think about it. We say that a minor can't consent to sex in the context of statutory rape. But the second that statutory rape involves a commercial transaction, all of a sudden that minor is now suddenly a voluntary criminal prostitute able to consent? It defies reason. A safe harbor law states that because no minor can consent to sex as a matter of law, no minor can commit the crime of prostitution as a matter of law, and it follows that no minor should ever be arrested for prostituting. In the recent case of In Re BW, the Texas Supreme Court held that prostituted minors cannot be prosecuted for the crime of prostitution. This is where courts should be heading. I'm happy to report that Arizona law enforcement agencies are increasingly beginning to treat prostituted minors as victims of sex trafficking rather than juvenile delinquents or criminals. But we need a law saying that a prostituted minor is a victim of sex trafficking as a matter of law. Federal law has so explicated since 2001, and 22 other states have these type of laws on the books. Genuinely well-meaning Arizona law enforcement officers still routinely arrest child sex trafficking victims as an initial matter because they believe that this might be the only way to actually extract them from their traffickers and connect them with the services offered through nonprofits. But I contend that it is a moral outrage to arrest a crime victim as though he or she were the criminal. In keeping with the notion that all prostituted minors are victims of commercialized child abuse, I would submit that a better approach would be to explicitly extend the jurisdiction of the child welfare system to cover trafficked minors, and amend the child welfare statutes to clarify that any prostituted minor can receive services through the child welfare system, regardless of where the parents are in the picture. This way, police wouldn't have to arrest the victim and say, complete these nonprofit services for victims, or else we'll prosecute you as a criminal. Instead, the child trafficking victim would be recognized as a victim, and only a victim, throughout, while still having access to the services available. The child welfare system could take over from day one and do its thing with its existing array of services. Drafting the right statutory language to achieve this result will no doubt be tricky, but that's why we have a room full of smart lawyers here. The legal scholarship cited in your handout provides more guidance as the brass tacks as to what other states have tried in this area and how we can continue to improve going forward. But the bottom line is this. The principle behind safe harbor is that any minor in prostitution is a crime victim, not a criminal. And our laws should come out and make that clear. Second item for reform: a statutory cause of action for trafficking survivors to sue their traffickers. This is an easy one, and I think it's very doable in our legislature. Currently, trafficking survivors can sue their traffickers for traditional tort causes of action like kidnapping and false imprisonment and battery and so forth. But quite often, these causes of action are dead on arrival because of statute of limitations issues. And they also don't squarely enfold the particular nature of the exploitation of human trafficking. There is no cause of action for trafficking as such in Arizona. Why not, though, turn every trafficking survivor in the state into a private attorney general? Wouldn't we nail more of the bad guys that way and hit them where it hurts, in their wallets? The Uniform Act on Trafficking suggests a statutory cause of action for trafficking with a 10-year statute of limitations. That's long enough for victims to heal a little bit, receive aftercare, learn about their rights, begin to self-identify as victims, which they rarely do as an initial matter, and usually not until after substantial counseling and aftercare services, and enough time to file suit. The 10 years in the model statute would run from the date the trafficking ends or the date when the victim turns 18, whichever is later. And the model act would also allow for punitive damages and attorney's fees where appropriate. 36 states already have some type of civil cause of action for trafficking in place as of 2014. We can get one done in Arizona, I think, and we should. And relatedly, it's time for us to dust off and improve our trafficking restitution statute. Arizona does have a statute on the books mandating restitution for trafficking victims. It's ARS 13-1309. But currently, it only kicks in upon the successful prosecution and conviction of the victim's trafficker for sex trafficking or labor trafficking under the ARS. So here's the problem. When prosecutors are encountering activity that meets the federal definition of trafficking, they typically aren't charging it under those particular provisions of the ARS in Arizona at present. They're charging it as child prostitution, or pandering, or receiving the earnings of a prostitute, or any number of other things, but not trafficking. One consequence of this that prosecutors might not be thinking about is that even if the bad guy does get convicted, even then restitution won't be available to the victim because it wasn't a conviction for trafficking as required by 1309. So I say we ought to broaden the trafficking restitution statute to reflect the reality on the ground. Make it kick in upon convictions for the statutory offenses that traffickers are actually getting convicted for. In addition, we should make restitution mandatory for anyone convicted of trafficking or related offenses, whether or not a trafficking victim is initially identified, as the Uniform Act suggests. If a victim of a particular trafficker then is identified within a 5-year period, they could get their restitution check then. The state would hold on to it for them. And if no victims have been identified within 5 years, then that trafficker's restitution money would escheat to a trafficking victim general assistance fund of some sort. Seems to make a lot of sense to me. So between a civil cause of action and a more potent restitution statute, we could see trafficking survivors receiving back pay, other compensatory damages, punitive damages, and attorney's fees. This could be a real game changer for survivors in their recovery process, and it would give them a measure of justice as well. Furthermore, it would mean a big hit to the traffickers' bottom lines, and economists tell us that that's one of the most effective deterrents of all. After all, traffickers are in it for the money, plain and simple. A U.S. sex trafficker can easily make $100,000 or $200,000 per victim per year and might have 4 to 6 victims on average. So we're talking big money. This is more lucrative and less risky than drugs. Criminals are doing the math, and that's why we're seeing an increase in human trafficking. But if more traffickers wound up having to pay restitution and civil judgments and so forth, it would significantly change the financial calculus, causing people to become traffickers rather than other types of criminals. And it would provide a substantial deterrent to complement that provided by criminal penalties. Fourth proposal is this: expand vacatur for victims. Trafficking victims are often wrongfully convicted of criminal offenses that they were forced to commit incident to their trafficking, most notably prostitution. I'm sure Beth will tell you shortly how her unjust convictions for prostitution incurred while she was a child sex trafficking victim continue to haunt her still decades later, make it hard to find work, hard to get an apartment, and much more. The state legislature passed a law earlier this year allowing certain sex trafficking victims to have some of those wrongful convictions vacated. But the bill is rather toothless. It only allows for vacatur of convictions specifically for the offense of prostitution under the ARS, not a conviction for prostitution under a local statute or a conviction for a prostitution-related offense such as indecent exposure or some other lesser offense that it might get charged as on the ground. Still worse, it only allows the bill only allows for vacatur of wrongful convictions incurred before mid-2014, not those going forward. This is based on the erroneous assumption that these wrongful convictions will not continue to be a problem. The thinking is that because in the ARS since mid-2014 there's now an affirmative defense to a charge of prostitution, that the defendant is a victim of sex trafficking, that now there won't be any more wrongful convictions because if a sex trafficking victim is charged with prostitution, they can just assert the affirmative defense and everything will be hunky-dory. But make no mistake, these unjust convictions will continue, notwithstanding the affirmative defense, because most victims won't be in a position to assert the affirmative defense in a timely way at the moment that they're charged with prostitution. Maybe they don't self-identify as a victim yet. Maybe their traffickers are forcing them to plead guilty. And on and on. The bottom line is that these unjust convictions will continue, and vacatur must continue to be available for convictions for prostitution and other minor nonviolent offenses incident to trafficking, or that are a direct result of the trafficking going forward. So hopefully the legislature will address some of these snafus in its first attempt at a vacatur law next time around. My fifth proposal is a John School. You've heard of traffic school? Well, I want to create an Arizona John School. Rather than just giving buyers of sex, the Johns, a slap on the wrist and telling them, oh, I'm going to go tell your wife, why don't we make them pay a big fine and complete a diversion program that's specifically aimed at reducing John recidivism? Have them go learn about the dangers of buying sex, the socioeconomic harms of buying sex, and most of all, the fact that that 19-year-old pretty woman, voluntary prostitute who's just so happy to be sleeping with them for money is actually a 15-year-old child sex trafficking victim who gets beaten every night if she doesn't make her financial quota for her pimp who's confiscating every penny. Most of all, have a survivor of trafficking physically come into the Johns School and tell them the real story. Charge Johns $1,000, $2,000, $5,000 for the privilege of participating in this program rather than going to jail. And have 100% of that money go toward funding an array of aftercare services for trafficking survivors. You would reduce John recidivism, you would fund survivor services without having to raise taxes or pull money from other programs, and you'd reduce demand for commercial sex, which is what is driving sex trafficking to begin with. It's a demand-driven industry. Everybody wins. So let's put our heads together and figure out how to get a John School going. And while we're at it, prosecutors, let's aggressively use our asset forfeiture laws to seize the vehicles and other incidents of crime that Johns use in committing prostitution offense. And let's use those auction proceeds for victim services as well. There was a survey done of Johns that asked them to rank numerous potential punishments for buying sex and say which ones were more likely or less likely to stop them from reoffending. The Johns survey, these are actual Johns, said that the seizure and forfeiture of the automobiles used in the crime would be a far stronger deterrent for them than jail time. So let's make that happen. Sixth, and finally, we should create specialty courts to deal with sex trafficking and prostitution. New York, Texas, and other states already have sex trafficking courts, and they've been pretty effective. In Tucson, we've got mental health court, drug court, homeless court, and so on. These programs are more successful than traditional enforcement models at addressing some of the root causes of crime, and they're arguably more humane as well. So let's create a sex trafficking court with a judge who's specially trained in the mechanics of human trafficking and prostitution, and send all the adult prostitution cases there. Prosecutors and defense attorneys can work together in this court to brainstorm creative ways to get prostituted people the services they need to actually exit trafficking and prostitution, rather than just showing them down to the jailhouse door, which, as we know all too well, is a revolving door, especially in the context of prostitution. Every person in prostitution is a victim of something, a victim of trafficking at worst, but at best, a victim of a sexist society that condones commercialized gender-based violence in the form of prostitution. Let's create a judicial institution that can tangibly help people move out of prostitution, rather than simply penalizing them for being in it. So again, the 6 changes that I would propose to Arizona's anti-trafficking regime. First, safe harbor, a law saying that children in prostitution are to be treated as victims in every respect, not as criminals. Second, a civil cause of action for trafficking. Third, tweaking the restitution statute that's already on the books to make it more practically available for survivors. Fourth, expanding avenues for survivors of trafficking to have their wrongful convictions vacated and removed from their records. Fifth, creating a Johns School and vigorously pursuing asset forfeiture against Johns. Sixth, and finally, creating a specialty prostitution and trafficking court. These changes won't happen on their own. We could kill several of these birds with one stone if we could convince the Arizona legislature to pass the Uniform Act on Prevention of and Remedies for Human Trafficking in its full form. It's a really good law if you read it, a really good bipartisan law. But whether that's politically feasible, I'm not sure. A piecemeal approach might be more realistic on some of these issues. But I do know this much. We need your help to get any of it done. If you're a legislator, if you're a policy wonk, if you're a prosecutor, defense attorney, lobbyist, you're at a big firm, you're at a small firm, please talk to me and my fellow panelists about law reform efforts and how you can help. We need pro bonos to draft the specific Arizona statutory bill language to implement some of these ideas. We need to get a coordinated ground game going to get this done at the Capitol. We need well-connected lawyers to help us get policymakers on board. Trafficking is a growing problem, and it's one without a simple silver bullet solution. But the changes I've outlined today would go a long way toward creating a victim-centered anti-trafficking regime in our state that gets tough on traffickers while providing trafficking survivors with more robust protections and helping them rebuild their lives. Thank you very much. And if you have any questions or want to get involved further, please do get in touch with me at the email on your handout. It's hallandyt@gmail.com. Thank you all so much for being here today.